Hello and welcome to today's webinar on rectification of wills, lost wills and the question of deathbed gifts. For those of you who don't know me, my name is Ali Toe and I'm one of the senior associates in the dispute resolution group here at Boyce Turner, and I will be hosting today's webinar. A few housekeeping issues before we start. This is a live webinar, so please feel free to post any questions you may have as we go along through the chat panel. This webinar may raise a number of questions, so please bear with me. I will try and answer as many as I can at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you. Although live, today's webinar is in listen-only mode. However, as I say, you can send us any questions or comments through the chat panel and I will do my best to answer as many of them as I can at the end of the webinar. So let's get started. Today's webinar is the third in the series of webinars that we are running about contentious probate claims. In our last webinar, we discussed the question of undue influence and forgery of wills. Today, I'm going to be talking about rectification of wills, lost wills, and the question of deathbed gifts. And still to come in the series is proprietory estoppel claims, Inheritance Act claims, and the removal of executors or administrators. Strictly speaking, neither rectification nor lost wills are contentious probate matters, but they can often result in disputes between families if one member of the family wants a will rectified but another does not, or in the case of lost wills, one member of the family produces a will seeking to enter it into a probate, but another family member says that it was not the last will and that it has been lost. So let's look at these two issues in more detail. Firstly, rectification. Well, as I've said, strictly speaking, it's not a probate claim, but rather relief of a claim for want of knowledge and approval where a mistake has been made in the drafting of the will. Claims are brought under Section 20 of the Administration of Justice Act 1982. The remedy is discretionary in nature. Personal representatives will also need to bear in mind that the courts are reluctant to exercise power under the Act unless there is no other way to resolve the difficulty. In some cases, rather than rectifying the will, the courts may choose to merely omit the words from the will. Any claim must be brought within 6 months from the date on which a grant of probate or letters of administration in relation to the deceased estate have been obtained. There is power for the court to extend the time, but circumstances would need to be exceptional. If there's no subsisting probate claim and the proceedings will not be opposed, then an application can be made to a district judge in the family division or a registrar in the district probate registry. If, on the other hand, the proceedings are opposed or there's a question of construction, the application should be made to the Chancery Division of the High Court. If, having brought the claim, what then are the matters for the court to consider? Well, there's three issues that the court will need to consider. Firstly, what were the testator's intentions? Secondly, was the will expressed in such a way that it failed to carry out these intentions? And thirdly, was the will expressed as it was as a result of a clerical error or the failure on the part of the draftsman to understand the testator's instructions? So let's look at each of these considerations. So far as the testator's intentions are concerned, the court will require strong evidence of the testator's intentions before any rectification will be ordered. The burden is on the person or persons bringing the claim, the claimant, to prove the claim on the balance of probabilities, so the onus will be on them to provide such evidence. Mere speculation will not be sufficient. Intrinsic evidence will be required. And so what then about a clerical error? Well, what is a clerical error? This has been held to mean an inadvertent error. The error may have been made by the draftsman of the will or the testator himself. A clerical error will extend to circumstances where the will includes something which the testator did not intend to include, or conversely, omits something which the testator intended to include. But it will not extend to where the testator failed to appreciate the legal effect of words used in the will. It will also not extend to circumstances where the draftsman thought about the words to be used in the will and included those words, but failed to produce the intended legal effect. And so what about a failure to understand? This has a far more limited scope under the Act than clerical error. It will only apply in circumstances where the draftsman misunderstood the testator's instructions. The remedy is not available where the draftsman's error is based on a failure to understand the legal effect of the chosen words in a will, or where the draftsman had thought about the words to be used in the will, and included those words, but the words failed to produce the intended legal effect. In considering the failure to understand, the court will depart from the traditional rule of construction that the testator's intentions are to be inferred from the wording of the will, and instead will rely on intrinsic evidence of the testator's intention. The Act envisages the involvement of a third party in the preparation of the will, and so the remedy does not extend to homemade wills. So what does all this mean in practice? Well, let's have a look at a recent case where rectification was ordered. So this is the case of Marley and Rawlings in 2014. In this case, the solicitor prepared wills for Mr. Rawlings and his wife. The wills were in simple mirror form, each leaving the other his or her entire estate, with the entire estate on the death of both of them then passing to Mr. Marley, who the couple treated as their son, but who was not related to them. As a result of an oversight on the part of the solicitor when the wills were executed, Mr. Rawlings signed the will drawn up for his wife, and she executed the will drawn up for him. Both signatures were attested by the solicitor and a secretary at his firm. The mistake went unnoticed in 1999 when the wills were prepared, and again in 2003 following the death of Mrs. Rawlings, and only came to light in 2006 following Mr. Rawlings' death. It's important when considering rectification to consider the provisions of the Wills Act 1837, which sets out specific requirements for a valid will. These requirements, found in Section 9 of the Wills Act, provide, so far as the signature of the testator is concerned, that no will is valid unless it's in writing and signed by the testator or some other person in his presence and by his direction, and it appears that the testator intended by his signature to give effect to the will. As a result of the mistake in relation to the signature, Mr. Rawlings' will did not comply with the provisions of the Wills Act and was thus invalid. Accordingly, Mr. Marley commenced rectification proceedings. At first instance, the court dismissed his application. Mrs. Justice Proudman said that the application must fail in view of the failure to comply with the provisions of the Wills Act. In case she was wrong about that, however, she then went on to consider the question of rectification. She said there was no error of drafting in the case, whether by inclusion or omission or miscasting of words. The wills were both correctly expressed. The error was simply that the wrong will had been tendered for signature. In her view, therefore, Section 20 did not provide a solution to the problem which had occurred, and she therefore dismissed the application. Mr. Marley appealed. The Court of Appeal agreed that the logical, indeed the only place to start, was the validity of the will itself. Lord Justice Black, giving the leading judgment, said he did not see how the validity could be approached except upon the basis of the will as it stands, albeit in the context of the circumstances surrounding its making. He found the suggestion that the court could rectify the will under Section 20 before considering whether it met the formal requirements of the Wills Act unappealing in principle. He also said he found it difficult to envisage how this would operate in practice. He said in the circumstances he would treat the reference to the word will in Section 20 to be reference to a valid will. He remained of the view that the formalities of the Wills Act were not satisfied in this case, and agreed, as Mrs. Justice Proudman had found, that the will was therefore not valid. As a result, there were no grounds for rectification, and the appeal was dismissed. So Mr. Marley then took the matter up to the Supreme Court. The Supreme Court did not agree that the will fell foul of the provisions of Section 9 of the Wills Act. Giving the leading judgment, Lord Neuberger said that whilst it was clear, even on a cursory reading of the will, that something had gone seriously wrong, it was unchallengeable that Mr. Rawlins signed it, that he did so both on the face of the document and as a matter of fact, with the intention of it being his last will. Thus, whatever else may be said about the document, it was on its face unambiguously intended to be a formal will, and it was signed by Mr. Rawlins in front of two witnesses on the basis that it was indeed his will. He went on to say that Section 9 of the Wills Act is concerned with formalities. The fact that it's pretty clear from the provisions it contains that a will may well face problems in terms of interpretation or even validity does not mean that it cannot satisfy the formality requirements. Mr. Rawlins had signed the will. It can only have been his will, and it was he who was claimed in the proceedings to be the testator for the purposes of Section 9. Accordingly, he considered that the provisions of Section 9 had been satisfied. As to the clerical error, he confirmed that clerical error should be given a wide meaning, and so would extend to the draftsman allowing the testator to execute the incorrect document in the belief that they were executing their wills, which the court said demonstrated the necessary intention as regards the testator's intentions. The court confirmed that a clerical error may extend to an error of an administrative nature and not just drafting errors. Accordingly, the will was rectified to reflect Mr. Rawlings' true intentions, entered into probate, and Mr. Marley inherited the estate as the couple had originally envisaged. Conversely, in Tankle v. Tankle in 1998, the court refused to grant rectification. This case involved a discretionary trust rather than a will. The facts of the case were that in 1967, Mr. Tankle set up a discretionary settlement for a wide class of beneficiaries, including his daughters. Originally, 2 accountants were appointed as trustees of the trust fund. However, in 1974, they retired, and Mr. Tankle appointed his daughters as the new trustees, along with his wife and a solicitor. Following the appointment of the new trustees, a number of appointments were made in favour of the daughters, involving substantial sums of money. A problem with the settlement subsequently came to light. The problem centred around the provisions of Clause 12, which were such as to prevent the daughters, with the other trustees, from exercising any powers as to cause any part of the income or capital of the trust fund to become payable to or applicable for the benefit of the daughters. Accordingly, Mr. Tankle and the trustees issued rectification proceedings. The court refused to grant rectification and dismissed the claim, resulting in all the appointments already made in favour of the daughters becoming invalid. The court found that the settlement document as executed had not differed by some reason of mistake from that which Mr. Tankle had intended should be executed. nor was there any evidence that the draftsman had departed from clear instructions when preparing the document. The court had no doubt that if the effect of clause 12 had been pointed out to Mr. Tankle, it's very likely he would not have executed the document in the form as drafted. However, that was not sufficient to order rectification. And then there's one final decision that I'd like to consider, which is the very recent case of Kelly and Brennan, decided in February 2020. In this case, as well as considering the question of jurisdiction, as the deceased was resident in Ireland at the date of his death, the court had to deal with an application for an extension of time to bring the claim for rectification. The deceased was Patrick Kelly. He died on the 9th of June 2014. He was one of 9 children. He'd never married and had no children of his own. One of his brothers, Vincent, was appointed executor of his estate and obtained a grant of probate on the 7th of November 2014. Within 7 weeks of Patrick's death, it was discovered that there had been an error with the preparation of his will. Primary limitation in relation to a claim for rectification therefore expired on the 7th of May 2015, but it was not until some 3 years later, on the 1st of May 2018, that the claim for rectification, coupled with an application for an extension of time, was issued. At the hearing of the matter, the court heard evidence that Patrick had had a meeting with his solicitor on the 5th of October 2010 with a view to giving instructions as regards the preparation of a new will. A handwritten attendance note had been prepared by the solicitor at the meeting, and he had subsequently prepared a typed version of that attendance note. The court was satisfied that the handwritten attendance note was a contemporaneous record made by the solicitor during a meeting with Patrick on the 5th of October 2010. That note made it clear that Patrick had wished to divide the residuary of his estate in 6 equal shares between 5 of his siblings, with the 6th share passing to the 5 children of his late sister Maureen, who had predeceased him. The will should therefore have recorded that the residue was to be divided into 6 equal shares and then identify the beneficiary of those shares. Unfortunately, instead, it simply listed all 10 beneficiaries and then added in the words, "in equal shares, absolutely." This had the practical effect of meaning that the residue was divided into 10 shares rather than 6. The effect of the error, if not rectified, was that Maureen's children would receive an unintended windfall from Patrick's estate. The monetary effect of this was that the 10 beneficiaries would receive a sum of just under 100,500 each, compared to just under 167,500 for each 1/6 share if the will was rectified. This in turn would mean Maureen's children would each receive a sum of just under £33,500. The court was satisfied that the error amounted to a clerical error, and so it then turned to consider the question of an extension of time. In this regard, the court heard evidence that following the discovery of the error, attempts were made to agree a voluntary variation of the will to reflect Patrick's wishes. Initially, it appears that all parties would agree to the same, but by May 2016, it had become clear that this was not the case. Thereafter, some of the beneficiaries sought to pursue a claim in negligence against the solicitors. This led eventually in November 2017 to counsel's advice being obtained, which advised that there were good grounds for bringing a claim for rectification. There then followed a period of delay whilst Vincent attempted to evaluate the claim, including the collection of assets held in Ireland, and there were also ongoing funding issues in respect of the rectification claim. The court noted that the estate had not yet been distributed, a factor which the court considered to be of significant importance. The court did not accept that there had been any undue prejudice to any of the beneficiaries as regards the delay in receiving their inheritance, albeit there were understandable frustrations in this regard. There had been an obvious clerical error in the preparation of the 2010 will, such that it did not reflect Patrick's testamentary intentions. It was just and proper in all the circumstances to extend time for bringing the claim. Permission was therefore granted to bring the claim out of time, and also rectification as regards the will to reflect Patrick's intended wishes. And so then turning to look at lost wills. Where a will cannot be found upon death, certain steps need to be taken before any application to court can be made. Inquiries should be made of the deceased family and friends. Also, if the deceased had a regular professional advisor or anyone is aware of the solicitor's firm that the deceased last used to prepare a will, inquiries should be made of them. Inquiries should also be made of the deceased bankers, as it may be they hold a copy of the will. And consideration should also be given as to whether to undertake a search of the wills register to see if it was registered. Lastly, consideration should be given as to whether to place an advert for a copy of the will in the local paper or perhaps in the Law Society Gazette. If none of the above searches result in the location of the will, then an application can be made for permission to enter the lost will into probate, notwithstanding an inability to produce the original document. This procedure would only apply to any will which had been accidentally destroyed. If no copy of the will has been found after the death of the testator, then there is a presumption that any previous will which he is believed to have executed has been destroyed and therefore revoked. There is no such presumption if the will was lost after the date of the deceased's death. The application is made under Rule 54 of the Non-Contentious Probate Rules 1987 to a registrar of the probate registry. There is no need to provide notice of the application to anyone, but the application must be supported by an affidavit. The affidavit must set out the grounds for the application and provide as much evidence as possible as regards the will's existence after the death of the testator, or where there is no such evidence, the facts on which the applicant relies to rebut the presumption that the will has been revoked by destruction, together with confirmation as to the circumstances in which it was last known to be in existence. It should also set out what steps have been taken to try and locate a copy of the missing will. The registrar may, on initial consideration of the matter, seek further evidence as to the due execution of the will, and may also direct that notice be given to any person who may be prejudiced by the application. It's always advisable, therefore, to see whether written consent can be obtained from any beneficiaries, and in particular, any person who may have been set to inherit under a previous will, but not the one which has been lost. If such consents are forthcoming, then they should be filed at court with the application. A draft of the missing will, as it is believed to have existed, will also need to be filed. So in the case of Rowe and Clark in 2005, Mr. Rowe had been in a relationship with the deceased for some 10 years prior to his death in January 2004. In June 2000, Mr. Clark had made a will in Mr. Rowe's favour. He had sent a copy of that to Mr. Rowe's mother, but after his death, the original will could not be found. In April 2004, Mr. Clark's brother Kenneth obtained letters of administration on the basis that his brother had died intestate, i.e. without a will. Mr. Rowe applied to court seeking an order revoking Kenneth's letters of administration and for a grant in solemn form on the basis of the June 2000 will. Kenneth opposed the application on the ground that as no will could be found, his brother should have been presumed to have destroyed the will with the intention of revoking it. He also issued a counterclaim seeking possession of his brother's house where Mr. Rowe lived. Kenneth contended that Mr. Rowe was no more than his brother's lodger or tenant. He denied that his brother was homosexual or that he was in a relationship with Mr. Rowe. He made no secret in the witness box of his disapproval of homosexuality. Mr. Rowe gave evidence that Mr. Clarke's will had been kept in an old filing cabinet, but that this was later disposed of and all papers in it were moved to the bottom of a wardrobe. Although he'd not looked for the will following Mr. Clarke's death, he contended that following an extremely traumatic visit by Kenneth to the house after Mr. Clarke's death, he believed Kenneth must have removed the will and thereafter fraudulently suppressed or destroyed it. Whilst the court accepted that the presumption as regards Mr. Clarke's destruction of the will existed in this case, the judge found that it was an exceptionally weak one. The court found there was sufficient motive and opportunity for Kenneth to remove the will if it was still in existence on the day of his visit to the house. However, there was no positive evidence of the existence of the will at the date of Mr. Clarke's death. In the circumstances, the court was not satisfied the will was in existence at the date of Mr. Clarke's death, and it followed it was not persuaded that Kenneth had removed it after his death. This left the court with two further points of consideration. Firstly, that the will had been deliberately destroyed by Mr. Clarke, or secondly, that it was lost or destroyed without that intention. The court accepted the continuing affection of Mr. Clarke's relationship with Mr. Rowe. Given this and Mr. Clarke's apparent desire to look after Mr. Rowe following his death, the court considered it unlikely he would deliberately destroy the will. To do so would also have meant he was prepared to allow his estate to pass to his brother, with whom he was on the most distant of terms and whom he had previously taken formal steps to disinherit. As to the question that the will was lost or destroyed by Mr. Clarke during his lifetime, but without any intention to destroy or revoke it, the court considered that this was not only possible, but probable. In the context of Mr. Clarke's lack of security as to how the will was kept, his history of alcohol abuse, and his having taken the unusual step of sending a copy of the will to Mr. Rowe's mother, the court found that Mr. Clarke considered this was sufficient and that this is why he was not overly concerned about the security of the original document itself. On the balance of probabilities, the court was persuaded that the will was not revoked and that the presumption, weak as it was rebutted. The court therefore allowed the claim, pronouncing in favour of the 2000 will and revoking the letters of administration to Kenneth. And then lastly, let's turn our attention to deathbed gifts, or more accurately, donatio mortis causa, which translates as deathbed gifts. And for ease, I'm going to refer to them as deathbed gifts. As I've already said, to be a valid will, a will must comply with Section 9 of the Wills Act 1837. Accordingly, as well as being in writing and signed by the testator or some other person in his presence and by his direction, and it appearing that the testator intended by his signature to give effect to the will, it must also be shown that the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time, and each witness attests and signs the will. By their very nature, deathbed gifts are such that these specific requirements cannot be met usually as a result of the testator's imminent death. In this respect, there's nothing particularly complicated about deathbed gifts, and in fact there's only two elements to a valid deathbed gift. However, they are essential elements. The two elements are: it must be a gift made in contemplation of and conditional upon the donor's death, and before death, the donor must have handed over the subject matter of the gift or some essential indication of the donor's title to the gift. Cases involving deathbed gifts do not come up that often. But there was a recent case back in 2015, and also one which is currently being litigated, which demonstrate the practical difficulties with these claims. So let's take a look at them now. So firstly, a case which has already been decided, namely King and Chiltern Dog Rescue and Another, a case heard back in 2015. Chiltern Dog Rescue and Red Wings Horse Sanctuary were two registered charities due to inherit, along with 5 other charities, the bulk of the estate of June Fairbrother, under the terms of a will made by her in June 1998. The estate, which consisted primarily of June's home, was worth about £350,000. Kenneth King was June's nephew. By the summer of 2007, he'd been made bankrupt twice and had also served a prison sentence of 12 months for acting as a director when he was disqualified from doing so. By this stage, June was becoming increasingly frail, and so Kenneth went to live with her. The arrangement was that Kenneth would care for June as and when was necessary, and in return, she would provide him with free accommodation and sustenance. According to Kenneth, June told him on a number of occasions that the house would be his after she died. Kenneth contended that June's words and conduct a few months before her death gave rise to a deathbed gift. He brought proceedings seeking to contend that June's property should be transferred to him and not the charities in accordance with the terms of her will. The relevant chronology of events was as follows. On the 19th November 2010, June wrote and signed a short note stating that in the event of her death, she left her house and her property to Kenneth in the hope that he will care for my animals until their death. At about the same time, June arranged to collect the title deeds to her property from the bank or solicitor's office where they were stored. Kenneth went on to say that about 4 to 6 months before her death, June handed the title deeds to her house to him and again said to him that this will be yours when I go. By this time, June's health was deteriorating. She was not yet bedridden, but this happened shortly afterwards. On the 4th of February 2011, June wrote and signed another document. This document said, "In the event of my death, I leave my house, garden, car, etc., and everything to Kenneth Paul King, same address, in the hope that he will care for my animals as long as reasonable." One of June's friends witnessed this document. On the 24th of March 2011, Kenneth prepared a so-called will for June, using a form of words which he downloaded from the internet. The document included a paragraph which stated, "I give to my nephew, Kenneth Paul King, my property of 12 Kingcroft Road, Harpenden, and my entire estate absolutely." June signed this document, but it was not witnessed by anyone. On the 10th of April 2011, June died. At first instance, the judge held that June had made a deathbed gift such that the property transferred to Kenneth upon her death. The judge considered that the words said by June to Kenneth in the 4 to 6 months before her death, together with the handing over of the deeds, amounted to a deathbed gift. The charities appealed that decision. The Court of Appeal found that when June had the conversation that she did with Kenneth about 4 to 6 months before her death, that she was not doing so in contemplation of her death. June was 81 at the time, but there was no evidence that she was suffering from any specific illness, and she had not visited the doctor for some time. If June was dissatisfied with her existing will and wanted to change it to leave everything to Kenneth, the obvious thing to do was to see a solicitor and arrange to execute a new will. The court also heard that the words "will be yours when I go" were more consistent with a statement of testamentary intent rather than a gift which was conditional upon June's death within a limited period of time. None of the documents which June had signed in 2010 and 2011 complied with the Wills Act, and so were of no effect, and none of the words which Kenneth alleged were said to him by June, as regards her gifting her property to him, comprised the essential elements necessary to be a deathbed gift. In the circumstances, the court dismissed Kenneth's claim, although he was awarded a financial award in relation to his cross-claim under the Inheritance Provision for Family Independence Act 1975. And then in Ivory and Ivory, this is an ongoing case where Peter Ivory is in a battle with two of his brothers over the distribution of his older brother Mick's estate following his death in November 2018. Mick did not make a will. His wife had predeceased him and he did not have any children. Accordingly, under the intestacy rules, his estate should have been distributed equally between Peter and his other two brothers, Alan and John. Peter had sole control of the estate and the distribution of Mick's estate, and he arranged to sell the house and then give all the proceeds of sale away to hard-working individuals and charities. Peter alleges that on his deathbed, Mick told Peter to keep all the money, and if he could not do so, to give it away. He says that Mick's entire plan was to ensure the rest of the family did not get their hands on his hard-earned money. Peter did not want the money, but was determined to carry out his dying brother's wishes. And so he took to the streets of Cambridge, handing out £50 notes randomly to homeless people. He also donated some money to other hard-working individuals and arranged for some valuable Osman memorabilia to be donated to the Osman fan club. Peter did not arrange to keep any records of who he gave the money to, how much he gave them, get details of their identities, or obtain any receipts from the money. He says he was simply focused on carrying out his brother's last wishes. Unfortunately, Peter has been unable to provide satisfactory evidence as regards the legitimacy of Mick's gift to him, and this has potentially left him in very hot water, as following the issue of proceedings by Alan and John together with Mick's nephew, the judge has recently made an order against Peter that he provide a full account of the money he has distributed. The judge has attached a penal notice to that order, and so if Peter is not able to demonstrate where this money has gone, he is at risk of being held in contempt of court, with the possible result that he could be fined or imprisoned. He could also be ordered to repay the monies to the estate. The net value of the estate amounting to approximately £450,000. Of course, it remains to be seen whether the court will ultimately accept Peter's claims that this was a deathbed gift. But in these circumstances, absent the necessary documentation and evidence to support his claim, Peter should have issued his own proceedings, seeking a declaration from the court that this was indeed a deathbed gift before he took steps to distribute the money in the way in which he's done. So that concludes my webinar on rectification of wills, lost wills, and deathbed gifts. Does anyone have any questions? So I can't see any, and nobody is immediately jumping forward. So I'll assume for now there are no questions, but as I said at the beginning of the webinar, if you do have questions that you prefer to put to me direct, then please don't hesitate to contact me. In the meantime, it simply remains for me to say thank you for listening, and I look forward to welcoming you to our next webinar, which is scheduled for the 27th of August, and when I will be discussing the question of who inherits and proprietory estoppel claims. So look out for more details about how to register for that shortly. In the meantime, once again, many thanks for listening. Thank you and good morning.